Hello, hello, hello. Good afternoon.
Good afternoon, ma'am.
Good evening, ma'am.
Good evening.
Okay, I see the numbers are extremely low today. Maybe because it's Friday. I don't know. Maybe we can give, I don't know, until 5:35. Let's give them 4 minutes to see if people would have joined, and then we can start. Thank you. Thanks. Okay, bye. Okay, ladies and gentlemen, I was finding out from Zuki so whether I should, I mean, I don't know, yeah, but she says I should proceed anyway. The numbers are still not looking near what they ought to be. But the session is recorded. Hopefully people will join us as we continue. So yeah, we start. And welcome to our last session for criminal court practice. And as we start this session, I just want to thank all of you for the participation, for those who are always here way in advance of the time. I appreciate the participation, the comments, the inputs, and I've also learned, a thing or two from you guys, and I certainly hope that you also have benefited a lot from this session, and I do wish you the best with the exams that you will write, and also with the entire PLT courses that you are still to do. And I look forward to see you in practice. In practice as defense lawyers, as we do have some members here who are still holding on to their previous titles, but I understand because, once you know what you know, it's very difficult to, to change yourself overnight. But I believe that in good time, everyone will wear this defense cap. And yeah, thank you so much for everything. So we start our session with now the methods to dispose. Please, I forgot the gentleman who got confused, but I think now he can see that we were first of all securing the attendance of the accused, then we were doing the methods to get the accused released, and now we are disposing of the case. So the first way that I would like to discuss as to how we dispose of a criminal case, it's representations. Representations are your submissions that you make in a formal or in an informal way. When we say formal or informal, we mean you can just have a brief discussion with the prosecutor in court, or approach the senior prosecutors in their offices, or you can actually reduce these representations down to writing. And in these representations, you are going to go into the merits of the case, and you will discuss the case that the state has against your client, and it would be maybe your view that the state does not have a strong case against the accused, and therefore you will be then asking for the case to be withdrawn against the accused, and you will state the reasons why you say that the state will not be able to secure a conviction if they proceeded with that case. Now, while doing this, ladies and gentlemen, you may also have to also disclose what is your intended defense that you would have raised to this case or to the charges if the case went to trial. So the only other important thing that you can note is that when you make these representations, you, especially when they are done formally and you are communicating with the state in writing, any offers that you make, what's happening? Can you hear me? Hello?
We can hear
Yes,
you.
Oh,
we can hear you,
Yes,
ma'am.
okay. I thought I got disconnected for a minute there.
You
Okay,
did.
so if maybe you are making some suggestions to settle the matter through alternative dispute resolution, you may be making certain admissions which can be considered to be something that can be incriminating on the part of the accused. And if that kind of information were to be disclosed before the court, it can be used against the accused. So to secure that any submissions that you've made or admissions or considerations that you've made, concessions that you made to the state, that such information should remain between yourself and the state. It is not information that they cannot go and later try and introduce in the court and use it as evidence against the accused. Then you may, in your communications, indicate somewhere on your representations that these representations are made without prejudice, and that implies that the state will not be allowed, if in court, because this is happening out of court. The representations is out of court. Now, if you are in court, maybe that whole process was not successful. Maybe the mediation or whatever you were trying to do did not succeed, in that the state did not, accept your offer to settle the matter, or they did not withdraw the charges. They decided to proceed with the prosecution. Then if they try to introduce those concessions, admissions, whatever offers that you made to them in court, you can get them blocked by saying such information is not supposed to be brought before the court because it was made without prejudice. Therefore, they are not supposed to do that. And the court will definitely not allow them to go on with introducing such information to the court. So in your representation, you can also make a request that, especially where your accused is taking responsibility for the commission of the offense. You heard me what I said. I didn't say he's pleading guilty. He's taking responsibility for their actions, that they have indeed conducted themselves according to the allegations made by the state. Then you say to them, the accused is taking responsibility for their actions, but there is a background to the matter, in that there is maybe something that has made the accused to act out in the way that has landed them before the court. And you will say to the court that maybe the accused has a drug abuse problem. So you are requesting that the accused, instead of them pleading guilty in court, in your representations, you are conceding to the commission of the offense, but the accused should not be made to plead guilty before a court. Instead, you are requesting that they be considered to be under a program for diversion. So if they are placed under a diversion program, you can make a suggestion depending what is the problem. No,
We lost
something is
you.
wrong. Can you hear me now?
Yes.
My network, I think, is not so good today. Sorry about that, ladies and gentlemen. So you will say, if maybe it's a drug abuse problem, maybe they can attend some drug abuse programs in Sanka, or maybe a rehabilitation center if the problem is severe, and maybe attend, maybe if it's a problem that maybe they have anger management issues, you can approach a NICRO. They have also social worker programs there that will assist with the accused working on getting some life skills and anger management programs. So when they go on that diversion, they are going to be in this program for a specified period of time. At times, you may actually have to wait to see whether the accused has completed the programs successfully. Because, as I think you may be aware, with people who have these kind of challenges, whether it's alcohol or drug abuse problems, they are prone to default in how they attend the programs. So before the state will actually now put them, or rather, if they put them on the diversion program, they will not immediately withdraw the charges. They will keep the case in court, and then they will inform the court that the accused is expected to attend at a specified place for a specified period of time, and they will want a report from the center where they were attending to say what kind of programs did they do and how did they cope in the programs, whether they were participating or they were defaulting, and if at the end of the program it was considered that they successfully completed the program and they have turned a new leaf. So it's not always the case that if you are asking for diversion and they agree that they can be in diversion, but then they will immediately withdraw. But this is good to suggest, especially when you are dealing with minor accused persons and maybe your more senior citizens or those who have substance abuse problems, or maybe if someone has a specified, you know, a problem like anger management and those kind of things, if they have never actually been found in court with having committed maybe violent crimes. Maybe this is a once-off situation, but they seem to be needing help in order to learn how to cope with their emotions when they are faced with anger and yeah, maybe those kind of medical conditions like your anxiety and things. So when you are successful there, then the report comes back and says it was good. They were good in attending the programs, and then the program was actually a success. Okay, sorry. With mediations, mediation it depends on the parties that are involved. That is the state witnesses, the defense witnesses. You can, as the defense lawyer, initiate the process to say you want to go into mediation, inform the prosecutor, and then maybe the parties can also be called maybe to meet with the senior prosecutors and everyone being present. Then you can have your mediation session, and there may be instances where you will see that it's necessary also that some not only to just agree, maybe where the accused is maybe just ending up saying, I'm sorry, they are just apologizing for what they did, but you may actually have to offer to fix maybe some something, if it was maybe something that was damaged, you can offer that. Maybe if it was medical expenses which were incurred, that the accused will now also offer to settle the medical expenses. And also, like instances where you have maybe a crime of culpable homicide and someone maybe has died from a car accident, but the accused, is taking responsibility, but you are mediating with the family. They are seeing that, maybe it's a matter that they could settle through a mediation. Offer maybe to pay towards maybe funeral expenses and those kind of things, to just make right, even though it won't obviously bring back the person who has lost their life, but offer to show remorse in a way of going beyond just apologizing and saying sorry. So that all happens in representations. And once you have done these representations, you can expect to be given a response that can also be in writing, to say whether the state is going to withdraw the charges or not withdraw the charges, or this diversion will be successful, and the accused can then go on that diversion or not. So the response will come back in writing. And I do wish to remind you that I said within the NPA, there is a hierarchy. So when you've started with your written representations in the court, maybe they were directed to the senior prosecutor and they did not agree with you. You don't have to stop there. You can decide to go beyond the senior, maybe take your representations to the chief, or even jump the chief and go straight to the DPP. So I can tell you from experience as well that sometimes the representations that you've made at the SPP level, they may not be successful. And I don't want to take it that it has maybe any malice in why they don't give clear consideration of your representations, no matter how good you may put them down on paper. But I have seen that in most instances, those representations where you had really good reasons which were refused by the SPP, if you proceed to the DPP, you are likely to get a favorable result. And I can only think that maybe that is because of the workload that goes through the desk of the SPP, because there's a lot of cases down there that they have to look at, and they may not take enough time to, investigate, the matter properly before they reach a decision. But I know that the DPP at times, after you've submitted representations, they may even call you and request further information from you before they give a decision, and maybe request contact numbers of individuals that maybe it may be the accused, that they want a cell number of the accused to meet up with them, maybe to interview them. They may actually even call the state witnesses in and not just read the docket and decide. So they do have a bit of extra time in their hands, I guess, to consider the representations. So this is very important also, ladies and gentlemen, because when you are to lay any case for those civil claims that are made to against the state for your malicious prosecutions, or, the state having unfairly and wrongly decided to prosecute a case that they ought to have never have, prosecuted, then if you have evidence that you have made written representations to them and they were not even giving you any valid reasons why, they just ignored your pleas for them to withdraw the case, that also can be useful in those civil claims. So if you didn't do representations also, then the question would always be asked, if you say the state should be is being sued for malicious prosecution, or maybe a unlawful detention, did you do representations to show the state that they shouldn't have proceeded with that case? So it's good and it's very important that you do those representations. Indemnity is the next method to dispose of the case. We are referring to your section 204, witness who is a witness that was initially an accused, right? And because of information that they have, which is either offered to the state by the defense lawyers, that the accused has information that is useful to you, and this is normally with multiple accused persons involved in the case, and you say maybe accused number 3 is going to be useful to you, state, consider turning this accused into a section 204 witness, and then it will imply that if they agree, that witness will be immune from prosecution if they cooperate with the state. Please note that in the proceedings with this case, where you are seeking to get the accused to be made a section 204 witness, they do not just immediately decide to turn them into a state witness. They will actually want that witness to come to court, testify about that information which is going to be useful to the state. And once they have done that, after they are done with giving their testimony, then they will pronounce to the court that in the middle of that trial, they are stopping prosecution against that particular accused, and they are considering them to be a section 2 of requesting the court to consider them as a 204 witness because of the evidence which was helpful to the state that they have just given. Okay, now if the state proceeds with a case where the state, what am I saying here? In proceeding with the case against the other accused, remember this is a co-accused. When they are proceeding with the case against the other accused, the state cannot solely rely on the evidence of this 204 witness to prosecute the others. They must have other evidence separate from this testimony of this 204 witness that is going to link those co-accused to the commission of that offense. I hope that is clear. So maybe they can have fingerprints, or maybe they can have a DNA. They cannot just rely on a co-accused who says maybe it's a gang rape, who says it was actually number 1 and number 2 who raped the girl. They have to have maybe DNA, or maybe another eyewitness who is also another state witness, not only rely on the evidence of this accused to prosecute and secure a conviction only on the evidence of this co-accused. Okay.
Sorry, Elsie. Good evening. If you initiate this section 204 as a defense attorney, are you not going to be looked bad by the other defense attorneys for the other accused persons?
No, you are acting in the best interest of your client. So you don't care whether the other lawyers, they like you or not. Unfortunately, the best interest of your client is that they have information that can actually rescue them from being prosecuted. And of course, we all know what is a 204 witness. It's a snitch. This guy was involved with the others, but he has decided, you know, sorry guys, for some reason, my network is also enjoying the weekend. I'm shocked also. Understand. I keep getting disconnected. I hope you didn't miss what I said. I was saying that this is a snitch. This is someone who was involved in maybe even the planning and the actual execution of the crime. But now, because they've been caught, he's deciding to save his neck and he's ousting the others to save himself. So yes, of course, the other accused are not going to be happy with that co-accused, but to us as defense lawyers, it really doesn't bother us because we are doing a job. We were not in any way involved in the execution of the crime. We are just doing our job, which is to legally represent. If somebody decides to be snitching on their co-accused, that is their issue and their problem as jitters in the place where they stay. They'll deal with each other man to man when they meet each other on the streets. For us, it's not our concern really. But of course, if you have that information from the instructions is that he's snitching, you cannot refuse to divulge that information because you are scared that the other lawyers will not like you. No, you snitch also with your client, shame, and then they will deal with the repercussions of the snitching. And of course, those lawyers, we are all professionals. We know we are just doing our job, and at the end of the day, we shake hands at the end of the day, and we all go home and sleep in our warm beds while other people will be lounging in custody. So really, it's not our problem. So yeah, Charlie. Okay, Charlie just ran away. Next method, ladies and gentlemen, is
Sorry, Elsie. Sorry, I was trying to unmute myself.
Oh, okay. You can speak, Charlie.
No, sorry, I just had load shedding. That's why I was
No
quiet for a
problem.
few seconds. I'm
Yes.
just curious about the section 204 witness. When does this happen? Is it after the snitch has pleaded? What happened to their
Yes.
charges?
The
Do
the
their
snitch.
charges get withdrawn or
Mm,
discharged?
mm. The snitch will plead with
Okay,
everybody else when they plead.
okay,
And then now, after everybody has pleaded, the prosecution, remember, you've already have an agreement that the snitch is gonna be giving them testimony. And they said we'll only withdraw the charges after he has
Yes.
testified about the damning information. So they will
Okay.
call the snitch to come to the stand to testify.
Okay.
And the snitch will give out the horrible, gory details of how they did it, and
Yes.
in testifying,
Yes.
he will not necessarily exclude himself in having partaken in the crime,
Okay.
but it would be more like telling the truth of what happened, and then according to of course the state, the 204 witness, to say this is what we did. Maybe they may even say that the reason why I can tell the court that number one did this and number two did this is because I was there with them when we planned the whole thing. I
Okay.
went with them to the place. We broke in together. So obviously it's also, if he was to be not a they robbed the victims at gunpoint, and you will say, if also themselves also they also took anything that they took, so they're not gonna play innocent. They will
Oh,
say exactly what they have done, which is also showing their role in the commission of the crime. But now remember, the one and two, they would have been saying they are not guilty, they didn't do it. But now this accused number three comes and says, no, we all did it together. And then then that, obviously after their testimony has been taken down,
yes.
instead of now them still being considered as an accused, the prosecutor is happy. He got all that, information that has nailed accused number one and number two. Then he will stand up and announce to the court that they don't intend to proceed with prosecution of this witness because they want the court to consider them to be a 204 witness because of the testimony that they have given, which is, being useful to the state, and it's helping them to secure a prosecution of the co-accused. So
Mhm.
then from that point, then once the court is satisfied, then with that request from the state, then the witness is turned into a section 204 witness, and then they will be ordered that they may stand down from the dock. Now they are no longer, they are pronounced as free to go because they are not an accused anymore.
Oh, no, no. Thank you so much, Elsie. I follow.
Mm.
Is it safe to say that the prosecution will know how they are going to plead prior to them pleading in court?
Yes.
Okay. Thank you so much. I follow. Thank you.
Yes. But the most important part is they will not let them go until they give testimony in court to say what they all did with the co-accused. And after they have said all that information that they want to prosecute successfully, those are those who will remain, then they will then excuse that 204 witness.
Thank you so much. Much appreciated.
Okay. But now I don't know how long they will survive on the streets, ne? Because it's dangerous out there. Yeah, so they have to somehow find shelter, and yeah. But it is what it is. It's there, the law allows it. So admission of guilt, ladies and gentlemen, it's the next method that we use to dispose of a case. You can, not you, because this hardly actually happens with lawyers involved, but lawyers do also get involved when it's those offenses that are really minor, and the accused will be informed by the prosecutor that, look, if you don't want to go through the court process and you are accepting that you are, you are accepting or you are admitting guilt, right, for the offense that you have committed, you don't have to do the pleading of guilty in the court. There is an option for you based on our agreement as the state and the accused, that if you pay an admission of guilt fine, then you will be excused from attending the trial. So the matter will be finalized once you have paid that admission of guilt fine. So the offer will come from the prosecutor, or if you as the defense were involved, you can request that they do consider allowing the accused, instead of going the court route, to plead guilty before a magistrate, that they pay that admission of guilt. The admission of guilt is not done in front of a magistrate. It's in the chambers of the prosecutors. If there's an agreement there between the accused and the state, and then you will then go to, the amount will be fixed of how much they are supposed to pay. Then there's forms that they will complete where they are admitting to the elements of the offense as they have been charged, and that they are now opting to pay an admission of guilt, and they will be also admitting themselves to a payment of this amount, which will then bring that matter to finality. Then they go to the clerk of the court, they pay that fee, and the fee can be very minimal. So when I say minimal, I mean the amount can be like 300 rand, you understand? So something which, if the accused is looking at the stress of going to court and, being in court, paying lawyers and all that, and you are told, look, if you pay an admission of guilt, which is maybe 300 rand, then this matter is over, So that offer, it's very attractive, ladies and gentlemen, especially when you are dealing with young offenders and people who are hoping that it will never be discovered that they were ever arrested for this minor offense. Because, people, once they know that, hey, so-and-so is being arrested, they are attending court, there's shame and the stigma attached to, now people start looking at you as some kind of a criminal, even if they don't have all the information, because society can they can judge you very harshly. And maybe even at work, they are hoping that, it will never even come up that, my employer would know that they were arrested, so they can just quickly get that matter disposed of. So I'm giving you all these scenarios to show you why this admission of guilt is very, very attractive. And people, they fall for it because they think it's the easy way out, right? And yes, it is, in that obviously they don't have to, go through the court process of appearing before the magistrate. There's a gallery full of people watching you, oh, even members of the media may actually be sitting in the court. And yeah, so it is something that people, they tend to jump at that kind of an offer immediately when it's presented to them. Only problem is this: the effect of paying such a fine. The implications are that this person is going to have a criminal record. That's where the problem starts.
We lost some network.
My network today, it's showing me flames, eh? I don't know, ladies and gentlemen. So the challenge is with regard to clients, and they got themselves into paying those admission of guilt fines that they would have a criminal record. So now, here is a question. You get a client who comes and says that, I actually didn't know. I thought it's like a warning kind of a situation, like a caution that don't ever do it again. Richard, what do you do if you meet this kind of a client, and how do you assist them? Because they will come generally when they are looking for work, and it obviously comes up when the future employer, a prospective employer, is running background checks, and they pick it up that no, you have a criminal record.
Thanks, ma'am Elsie. I see you called my name once again.
No, I called because your hand was up.
Yeah. and I'm glad that you're touching on this section 57. Because especially in a job, when you apply for, I call it job, not work. We all job, you know.
Yeah, we are job seekers.
Yeah. And during COVID, and I brought this up in the ethics lecture, where it says a fit and proper person. But a fit and proper person does not know during COVID, including myself, without prejudice, we all committed criminal offenses.
I love that. The lawyer speaking so that you are covered.
And many of my learned colleagues, including you, sitting here today, do not know that we have criminal records due to COVID. You know?
Well, I actually do, because I've just gone through a new job process that I was. So they wanted my thing.
Are you making admission in terms of section? In terms of section 216,
I had to approach the LPC and get my all my documents, guys.
So do not make an admission or confession at this stage in terms of section 216 or 217. And what I want to say to most of the candidates, because I don't want to disclose where I work and what I do, is that recently we employed forensic accountants, forensic investigators, forensic lawyers. And when we done the screening, we picked up most of them, or not most of them, but some of them has section 57A admissions. And because they paid the fines, and some of them were advocates that was appointed. But at the end of the day and for me, that section 57 and section 7A capital is not in line with section 35 of the Constitution. And that needs some amendment to be done, because when the person gets the fine, the person that writes that notice doesn't warn that, or the police officer does not warn, or the peace officer, let me use the word the peace officer.
Peace officer, you are right, yes.
Does not use, or nowhere on that notice that they issue in terms of Section 57A, this is your rights in terms of Section 35 of the Constitution. And like I said, you brought memories back last night on Section 60 of the, I call it the Bail Act, in terms of the CPA. Yeah. And that needs to be looked at.
Yeah.
Section 57 is not in line with the Constitution. And I'm going to throw this bombshell out there for everybody. I am busy with my master's in constitutional law that I'm dealing with Section 35.
Okay.
Yeah. So we must be careful when you, it's like the lecturer on the let me see if I get a name here, on ethics. You go to the judge, they swear you in, and my learned friends has been there on that same lecture. You get to court and they say, but this person is no longer fit and proper person. What do you do? You know, and we have to be careful on that Section 57. That Section 57 needs to be amended. I hope.
Maybe you'll be the one to push that case for everyone. Yeah, since you fully are, aware of how it's really affecting a lot, especially candidate attorneys, because we get, a lot of candidate attorneys in our establishment where I work as well. And there's disclosures, obviously, during the interviewing process where they are asked, is there any disclosures that you would like to make? And of course, a couple of times I can tell you, they've come out and said, I have a previous conviction when I was still young, or some they'd say no, but then when they'd run the background checks, those admission of guilt fines for like shoplifting when they were like, 17 years old, or maybe 20 at university when they were busy being naughty with their friends, they come up, maybe they got into a fight after a party, at college, and somebody ran to the police to open a case of assault because, of course, they were assaulted. And instead of running the trial, the police just said, look, you both are students, you have your whole lives ahead of you. Come on, just pay a fine, or a guilt, or admission of guilt, and the whole thing goes away. And this person is thinking, my parents will never have to know, the university never has to know, this is just between me and the complainant, and they pay. And then boom, you are now a job seeker, and it comes up.
Yeah, and another thing, I love criminal law, but I don't want to keep most of your time up and the students up. It's the same like when you were youngster, and you mentioned it earlier in your lecture. Today we have the criminal justice system that deals with youth.
Like the children's court dedicated,
yes,
the criminal
yes.
court dedicated to dealing with children offenders. Yes.
Yes, and if you read some of the legislation, and I've read up on the criminal for child justice, where you want to prosecute the child, that act doesn't speak before the act. But if you go look at the Prevention of Organized Crime Act, it speaks about before you get the proceed of a crime, which is, and I don't want to go into the child's rights here, which is that
another whole topic. Yes.
Yeah, thanks, Elsie.
Yeah, but yeah. So the question would be then, with this admission of guilt, when you get a client who says, "Look, I want to challenge this. I wasn't fully aware of the repercussions and the consequences of me paying that fine." Maybe what can they do? Like, what would you think? Can they appeal? Take this matter to appeal? What can they do? Can they take it on review? What can they do? Anyone?
I'm not answering, Elsie.
I think my family wants to.
Good evening once again. Yeah, I think you'll have to apply to the court for the criminal record to be expunged.
But expungement is only if it's 10 years. The offense must have happened at least 10 years ago. So what if it's not yet 10 years? That's why I'm asking, is appeal really an option that you can consider? Maybe
Or a review. Yes.
Review, I wouldn't say so much, because remember, this didn't happen in front of a magistrate, but at least an appeal.
Yeah, I think it's an option as well.
Stating which grounds? I didn't know. It's not the defense in law.
Yeah, I was not informed
I'm just saying,
about the
sorry.
implications. I was not informed about the implications when I paid the fine.
But you signed for it. What did you think you are signing? Ignorance of the law?
Yeah, it's not an excuse.
Janus, please say something. Save us. Vanessa, anybody, please.
I think you go for ignorance of the law because, for instance, if the defendant or maybe the person who pleaded guilty is an illiterate who does not understand what is written on the paper, or maybe what is explained in a specific language, for instance, English, then that could be a defense.
You are dragging it, Akas. We hear you. But what if it's you? You are a learned person. I'm not saying you like the person is learned. I hear for the person who doesn't know how to read, maybe they can try that. But for someone who's learned, that may not be a good defense.
Maybe read Rex versus Blom.
Sorry, ma'am, just for clarity, what was the question again exactly?
Hello?
Yes, ma'am. Sorry. Just for clarity, what was the question again exactly?
I'm saying when you have a client who has actually paid that admission of guilt fine, and they say they want to challenge this criminal record, that it must be set aside, through maybe an appeal. I'm saying, what would be your grounds that we can raise to challenge that conviction to be set aside? Or any other thing that you think we can do to help this client?
I'm going to try not to mention names, but I did have one case where the magistrate and I both sat down. I was actually called into chambers and they asked me to address them on this aspect. But what I argued was the admission of guilt that was signed, can it be deemed to be a contract? The magistrate said, well, it's not a contract because it's not between two parties. And I said, well, it is because it's between the state as a juristic party and the individual. So it's a contract between parties. So we agreed on that. Okay. Then I said there are certain clauses and certain instances which would render a contract void. For instance, undue influence, under threats of violence of any kind, as well as the standard clauses, misrepresentation of parties and all that. What it came down to is, when I asked the client, why did you sign the admission of guilt? He said, because they told me if I sign this, I can go away, I can go on with my life. And I said, no. Why did you sign that admission of guilt? Not because what they said you can go free and all that. Why did you want to go free so badly? And he said that his boss that he was currently working for was such a cruel, hard, and unrealistic man. No emotion. He was no emotions whatsoever. If you made a big mistake and you didn't apologize for it, he would fire you on the spot. Horrible working environment, but good pay. So I said, okay, when we go to court again to raise this, to say to raise this before they say the case is going to be the case is being settled because you did that. I want you to testify to exactly why you wanted to sign that admission of guilt and what the reason for you wanting your freedom so badly was. He stated his entire case, and the magistrate sat there and he looked at me for about 3 or 4 seconds and he asked me, Mr. Kruger, are you really going to pursue this argument? And I said, yes, Your Worship, I am, because on the plain face value at the basics of law, the argument is valid. The contract was signed because of undue influence. It was a threat to his general well-being, his way of life. And because of this threat, indirectly from the state, this admission of guilt was signed under undue influence, therefore rendering it completely invalid. And the judge accepted it. He said that the admission of guilt is set aside. We're not going to accept it. We will move this matter forward for argument, and instead of bail, the client was released on unrecognizance. So I'm not saying that it's going to work for each and every single case. Depends on how you make it out. But there are ways in which you can say an admission of guilt can be seen as a contract, and it was entered into for fear, for threat, under pressure of, and try to get away with it.
Bear with me, ladies and gentlemen. I think what I'm gonna do at 7 when we take our break, I'll log out and see maybe if it will be better when we come back after our break, because it's just irritating me right now. So yeah, but I was saying in answer to Janus that I mean that admission of guilt is made at a match court level. It cannot be overturned by another magistrate. It would be only a court that is at higher level than the match court that can pronounce whether that agreement was valid or invalid through you following the appeal process. So that magistrate maybe indulged you. I don't want to pass too much judgment on them, but the law doesn't operate like that. Maybe you were lucky, Janus. I mean, of course, you went home smiling because you got what you wanted. But if it's really a magistrate who follows the law as it stands, it doesn't happen like that. It has to go through a high court, and only a higher court can decide whether that admission of guilt should stand or not. So, but yeah, it was your lucky day. That's what I say.
I'll say, if you don't mind, if I'm coming in here, and I think a very important case is Mong, M-O-G.
Please type it in.
I'll type it in. And,
yes.
And the candidates must read the case Mong versus Director of Public Prosecutions.
I think it's
a case Mong, M-O-N-G. And Justice Henny. It was a 2019 case, which is well in with our constitution. And I can say a lot of students must read that, or candidates, is to read that case. It's a very interesting case. Yeah, I will post it in the chat group later.
Thank you, Richard. Nontobeko, your hand has been up.
Hello. Oh, hi. Thank you. I think I just wanted to gain clarity on calling the admission of guilt or qualifying it to be a contract. I don't think I sort of did understand the reasoning why that would be considered a contract, because it is a fine that came about because of a fine. Sorry,
Not a fine, a conviction.
oh yeah, it's a conviction. It's a conviction, right? So why then is there you admitting guilt and offering an acceptance? Because who made the offer for you to accept it? Because it's an offense. So how does it overlap to being a contractual agreement than it to being a consequence of an offense?
Yeah, that is why I said it was Janus's lucky day. The way an admission of guilt works, once the person admits to having committed the elements of that offense as stated out in that form, they are binding themselves to be guilty of the offense. So it is tantamount to a conviction that would have ordinarily been pronounced by a court. That is why after you agree that you are making those admissions, your guilt is attached to your admissions. Therefore, the next thing to follow, you must be given a sentence of a fine, which will be fixed or determined by the prosecutor. You understand? So that is why I said, please, maybe just read the section again, section 57, read it again and fully understand how it, from you making admissions of you driving a car without a license, as the law says, a driver on the road must have a driver's license, and you fail to produce a driver's license, then you admit that you are aware of the law of the country that states that every driver on the road who is driving a motor vehicle must have a driver's license. You admit that by you driving a car without a license, you are guilty of the offense of driving without a license. That's a crime, and you are admitting to guilt. So then, but this happens, obviously, I said, outside the court, but at court. So you will just go and pay the fine after you've signed. And the effect, it's that you will have a criminal conviction. I mean, a criminal record based on your admission of guilt for your conduct. So I don't even want you to confuse yourself too much about the contract and what this one is a criminal matter, and the Criminal Procedure Act has included it. Check the section, read it, and fully understand why it's not a matter of really contract law. It's a matter of you having committed an act which in law qualifies as a crime, and your conduct is in line with the elements of that offense, and you admit that you did what the crime stands for. So the only difference is that this is done not in front of a magistrate, but in front of a prosecutor, and you will go and pay your fine in the clerk of the court. The law allows for that. So please don't confuse yourself with the contract issue. That's why I said it was Janus's lucky day. The law is there, and we should follow what the law says. But of course, that magistrate decided to indulge Janus. So yeah.
Yes, ma'am. In my defense, I see Vanessa also raised it. I just quickly went through my heads again. We argued it on section 3044 of the CPA, but along with that, it was a very young magistrate presiding.
Yeah.
And yeah, as I stated it here, when I don't want to say when news traveled, but when the magistrate set it aside, one of the principals came to me afterwards. He was a senior attorney at that point, very, very senior. When he pulled me to one side, and in his own words, I won't forget it, he said, "I've never seen anyone arguing the biggest load of rubbish without a single basis and getting away without reprimand. So it was a 1 in a million kind of case, that one.
So, sorry, Elsie, I just want to check what Janus, you mentioned section 334 of the Criminal Procedure Act.
He's saying 304.
Yeah, 304. Sorry, Richard.
Okay. I was just worried about there because 334 relates to the minister's responsibility.
Yeah.
And 304 relates to the procedures on review.
Yeah.
So I was just worried about there because if you look at the Criminal Procedure Act, when you appear before a magistrate and whatever happened in that chambers, I do not want to know.
I can promise you there was no bribery of any sort.
Yeah, maybe just laziness on the part of the magistrate to read.
But what I want to bring out there is and it links to section 57 and section 50 capital A relates to the admission of guilt that will lead you with a criminal offense. And it links in with the admissibility of a confession where a person makes a confession, whether it's in 217 or 216 of the Criminal Procedure Act, but it must be in line with the Constitution section 35. And for criminal lawyers who wants to go and to do criminal prosecutions, you need to know out of your head section 35, as well as the Bill of the Rights throughout. So, Vanus, jy was gelukkig.
Yeah, it was. It was a lucky day. It is no such a thing,
I think, honestly, if I tried that argument in front of any magistrate, they'd stop me at contract and say, Mr. Kruger, go read the CPA and come back to me.
Yeah, because Vanus, I was like worried there about you when you said 334. I'm a walking dictionary when it comes to CPA and the constitutional law. Sorry.
Does that make you illegal to take along when we're writing our boards, just as an advisor?
He has to write his own. He has to write his own, guys.
Janus, Google me.
Thanks, Richard, will do.
Yeah. So please, the law is clear. Section 57, it's allowing for this, and it's in terms of the Criminal Procedure Act. So the only thing that I wanted to dwell on was how do we assist those who are coming with claims of not knowing, not being aware, not being fully having comprehended the consequences because of the advice. Because this, I do have to say, it happens fairly quickly, and the way the offer is presented, it's not like the full legal implications are going to be emphasized to the person that, someone will say, are you sure you want to sign this? No, it will be like, my man, come on, just pay this. And you know what, like what Janus's client was saying, I thought, it's gonna just bring this matter to an end and I can go home. Most of the time they would say, I thought if I just pay this money, it would bring this matter to an end and I can just go home. I didn't know the full implications of what I got myself into. And my answer to help them while the 10 years has not yet expired is to take the matter on appeal. Then you'll argue on the grounds of the full implications not having been, explained. Because when a person is signing into this, maybe you can, even if they can say that they know how to read and write, but if legalese is a language for lawyers. So if it's a legal document, that form that they complete there in court, the handwriting, the writing in there, it's just a lot of things that this person is in trouble, he's nervous. They may not even like sit down and even read it fully before this. Once they're shown that, look, if you pay 300 rand, this matter is over, just sign here. What do you think? They're going to take the form and just sign and then go to the clerk of the court, pay the money. So we know even lawyers do that. Really, even lawyers sign things that they don't know what they're signing. You understand? It's not everyone, when a document is presented before them, that they will say, oh, wait, what is this? And then they will say, okay, give me some time, I need to read it. I used to see it a lot, even at the place where I worked, that once you just shove something in front of them and you're like, please, I need a signature here, just witness this for me. That's it. Or even because of trust, because of, acquaintance, because of, the pressure that they're under with whatever they are involved with, their own work, they may not even say, what am I signing? It happens. So I think appeal is definitely the route to go. And I don't see why you can't succeed with that. All right, so we move on. Plea of guilty is the next. Oh, I think I'm going slow. I need to pick up speed.
Sorry, Elsie, can I ask you a question? I have my hand up.
Karabo, we need to pick up speed there. Otherwise, we're gonna have to be here tomorrow night.
No, it's really a quick question on the
I'm
basis of.
joking. We're gonna finish,
No.
but
It's
yeah.
okay. I just want to ask you one question. You mentioned the matter of expungement. Just you don't have to dwell too much into it. The matter of expungement. So in the process of say you're applying for whatever that you do, the examples that you made, and you don't mention that you've had a criminal incident many years ago because it's been expunged. Would that come up, or do you still have to mention it as
No.
Okay.
The expunged one is supposed to be removed from your record.
So you don't have to say anything. You keep quiet and you move on.
Yes.
I'm just checking. Thank you.
But if somebody at the South African police records decides not to do their job and not really remove it everywhere, because I told you with human beings,
No, thank you, Elsie.
Yeah, so I would, if maybe you are in that position, Karabo, maybe just before you go for the job, just go yourself and check your record before you say, I don't have, just to make sure. And of course, if you pick up that they haven't mistakenly removed it, then you get it removed. Okay.
All right. Not a problem. Thank you.
Okay. Plea of guilty is a popular one, ladies and gentlemen. It's a exam question with the school, with the boards. You can be asked anytime to draft this guilty plea. Guilty pleas are popular because they bring, sorry, can you, the background here. Who is that? Can you mute, please? Samson, please mute. Samson, you are disrupting the class, please. Mute yourself. Okay, done. Thank you. Okay, plea of guilty. People are enjoying their Fridays at our expense. A plea of guilty is going to shorten the court proceedings, in that if the plea of guilty is accepted, there is no need for the state to lead evidence as in a trial. Avoid use of pro forma pleas where possible, as they are limiting, and it's best to prepare your own draft. So you with a guilty plea, you capitalize on the fact that the accused is willing and volunteering to plead guilty. And therefore, they are not wasting the court's time. They are playing open cards with the court, exposing themselves now to be at the mercy of the court in terms of the sentence that would be imposed on them. And you can even say they have shown a sign of remorse. They have taken responsibility for their actions. They accept that, of course, after all, they have to still be punished for their actions. So guilty pleas, we do them in terms of section 112, section 112. It can be done by the court with the accused, and you, if you are involved as the lawyer, then you can draft a statement in terms of section 112, subsection 2. Lawyers should always act in the best interest of the client. And money should never be a motivation to want to speedily dispose of a matter at the expense of your client. Because this guilty plea, it's something that is quick to do. Therefore, the matter can be finalized speedily. Of course, even if that is the case, you have to clearly consider that it is actually the right thing for the accused to do. You can use a plea bargaining procedure when you are entering into a guilty plea. You can do it formally, you can do it informally, and the idea is that you are trying to get the best possible outcome, despite the fact that, of course, after your guilty plea, the accused is still going to be found guilty, but you are trying to minimize the impact of, the blow that the accused is going to get when they face the consequences of their action. So in this plea bargaining, you can plea bargain about the charge to say, look, I'm not going to waste your time, Mr. Prosecutor or Miss Prosecutor. My client is pleading guilty to the offense, but I've consulted, and there are some elements which are missing from their admissions or their intended plea. But because I don't want to drag the matter out, can you consider a plea on a lesser charge than this one that you've preferred against the accused? What you are looking for there is the hope that if they accept your request to plead on a lesser charge, then even the sentence the main charge that you would have pleaded to. The plea bargaining you can do by confronting the prosecutor in your with a prosecutor, if you want to make so they in terms of any other offers that you would like to make. So or sir, are you ready? I'm ready, my watertight. I've got an identifying eyewitness. I've got a positive fingerprints. I've got a positive ID parade. You also play the same card with them and say, I'm not going to waste your time. Please, my client has already expressed the intentions to plead guilty, but please, let's bargain on the charge. Let's also talk about sentence. Maybe you now want to get the client to not even go to jail at all if it's not something that can, if it is something that can be avoided. Then you'll say to the prosecutor, please, my client is willing to pay a fine. And you even say they are already in their, in my instructions are that they are already in possession of at least, 3,000 rands that they are willing to pay towards a fine. Wow, that all sounds like a really, really serious accused who is showing commitment to get their matter disposed of without wasting anybody's time. And then now you say to the prosecutor, are you okay with my suggestion? You discuss, and you reach your own agreement. Once they agree with you, you can go as far as saying, okay, that's to seal the deal. Please, let's approach the presiding officer in their chambers. Let's go and inform the magistrate of our discussion and our agreement. And then we make our suggestion to the court based on our agreement concerning the suitable sentence that you will both be asking the court to impose. Remember, the state is the dominus litis. So once they have agreed on that lesser charge, it's not an issue to debate with the magistrate. The only thing you're going to debate in the chambers with the magistrate is the suitability of your suggested sentence. You cannot dictate to the magistrate on the sentence that they must impose. You both come in there and say, we are suggesting, based on our discussion and agreement, is that the both of us, we are amicable to the court granting a fine. And you'll state the reasons that will then press the presiding officer to now see that, okay, this is a first offender, the items have been recovered, the items have been fixed, whatever. So you are already somehow mitigating in front of the presiding officer in the chambers. And you may actually leave the office I don't particularly disagree with you, so it's fine. Go ahead and prepare your plea. I'm coming in court when plea is accepted as evidence against the accused, and based on that, the accused is convicted as they have agreed or admitted all the elements of the offense, and the facts that you've put in your statement are in line with the state case, as the prosecutor would have confirmed. Therefore, the accused is found guilty. Now you come to mitigation. When you mitigate, you will not say, Your Worship, we came to see you in the chambers and we've discussed this matter beforehand. You will say, Your Worship, the state and the defense have entered into a plea bargaining procedure, and there is an agreement that has been reached between the state and the defense regarding a suitable sentence that is to be suggested to the court, and you will say what is the suggestion, and you will then continue to mitigate. And then the state can also confirm that indeed, as per your plea bargaining agreement, that you have both agreed that a sentence suitable to the accused is a payment of a fine of 3,000 rands. And that is what you are requesting the court to impose on the accused. Will also stand up, confirm that indeed there was a plea bargaining process that you underwent and agreement was reached, and the state is also not opposed to the suggestion of the defense of the sentence that you are asking, and the court may proceed and pass sentence as per the request made by the defense. That's how you will deal with it. Now, please note, when you are in the chambers of the magistrate, they disagree with you. They can disagree with regards to the sentence that you are asking the court to impose. They are not forced or bound to your agreement as the state and the defense, because the court is independent and it should exercise its discretion without fear or favor. So only if the court finds that your suggested sentence is what is suitable to be imposed for the kind of act that has been committed. So the act and the sentence should coincide. If they are comfortable with it, then they will likely grant your request. But even as you come to court, after they've told you in the chambers that no, not a fine. I want this guy to go and sit at least 6 months or 1 year, doesn't. You continue to make your request as per your agreement. You have done a guilty plea also.
Elsie,
you can. Yes.
We are losing you in between.
Yes. Okay, fine. Let's stop here. Let's resume at 10 minutes. It's 17:15. Let's make it 11 minutes. Let me see what's going on with my network, and yeah. 10 minutes break. Thank you.
Should I play the song tonight or not?
Leave.
You're welcome. You're welcome.
It's Friday after all.
Tell us what you do.
Okay, let me play you the song while we're on a break. Let's do this.
Let's do it as long as we can dance.
And only on condition that you tell us what you do, Richard.
Guys, you don't want to know. I think I just found out, and I'm
I
not saying
know.
anything.
Yanis, I'm coming for you.
Richard, I just want to know, did you get a chance to drive on the Autobahn?
Yanis.
Let me play a song for you guys. It's Friday night. It's Friday night, so let's do this, guys. Come on, come on.
As long as it's a piano.
Okay, so let's see quick. So here we go. So here we
For
go.
real, guys. It was late to tell us about the COVID break.
And Elsie, the song also goes out there for you while you try to reconnect. We'll go for the ad break here while we're waiting for the song here. For Elsie's here. And here we're going to play the next song. Welcome to Lead FM. And the song was out there to all the candidates. Though it's Friday. Please release me.
What?
The songs are there to all the candidates tonight on Lead. So let's go for a break. We'll be back in the next 15 minutes.
Ten.
Cora, are you okay?
Oh gosh.
Yes, ladies and gentlemen, that was Cora.
Oh, the song is just was played here by Cora van der Merwe. Yeah, Cora. Yeah, come, Cora. Let's check.
Yes.
Let's go. It's Friday.
I just wanted to remind everyone there's also a Van der Merwe present.
I guess that makes it a special dedication.
There was a song out there going, someone that read on summer, I'm a piano. So here we go. My name is Richard. I'll be your host here for tonight here on Lead FM. So let's go for it.
Okay, right.
This is another presenter that you.
Oh yeah, pretty. I see you on the dance floor. Come on, Jans. Veronica, let's take it on here. Keep it mild here tonight here.
You actually have the voice for 702, Richard. You must reconsider.
Yes, and you know you actually.
I see. I just got a WhatsApp here from Maboleng. Maboleng, how are you? I believe that you up there in Pretoria. How are you doing there?
It's a good thing these proceedings are recorded. It's a good thing these proceedings are recorded, eh?
Janus, I see you up. I just got a WhatsApp there from you. Also, you're enjoying the tunes here. What you're saying here? In the Northwest, I see you. Are you hunting up there, or what's happening there? How's the weather there, brother?
The weather is freezing. Thank you very much, Richard. It is absolutely freezing looking over the dam this side, eh?
Yeah, Janus, I'm going to play a special song here for you. We're going to play some a very beautiful song, and we're all going to sing it together here tonight. Are you ready? Are you ready?
I'm not going to promise the safety of anyone's ears or hearing after this, but we're ready.
And here we go. He call me Boka. Everybody go. He call me Boka. He call me Boka.
Oh.
We will have an ad break and we will go for the news now. Good evening. My name's Richard and we're reading the news here tonight. We've just heard.
Right, Richard. Appreciate it. I'm here with the news for you guys this evening. And in current affairs, the Senzo trial is still going on.
Wow!
Come on, Janus, you can do the traffic. Come.
Good.
All right, that's it from me. I'm going to give it over to my colleague, Hannes, with the traffic. How's it looking?
Thank you very much. Well, when we take a look at the N1, congested as always, apparently there was a head-on collision between two trucks and a taxi. The medical personnel are currently on standby, along with police blocking of the two left lanes. Traffic is moving a bit slowly there. When we take a look across the roads of Johannesburg, we can see that there's a bit of a hold-up at OR Tambo. We're awaiting the return of the box players after their brilliant match and on their way over to New Zealand once again. Traffic is standing up there with the paparazzi covering it all. If we look at Pretoria, all seems quiet tonight. It seems we have a lot of verpas on the road tonight with a beautiful show going on there. Get on down to your local highway and you can see the proceedings moving forward. That's all on traffic from my side.
Thank you, Janus, for that. Welcome to Loftus Stadium tonight. It's Richard sitting here with Tox van der Linde in the studio here tonight. And on the field is Elizabeth running out. And Elizabeth is running out and is passing the ball to Cheston Colby. And Cheston Colby is passing the ball to Sia Kulisi. But then the Springboks come in and they wing it on the wing. And there's no try. Janus, do you want to carry on?
Guys, let's carry on. So I should think that the network issues will be resolved, and yeah, I'm concerned about time now. So we still have a bit to cover. Yeah, so I was saying that when you are dealing with a guilty plea, when you are getting into the sentencing stage, you have options to consider getting a pre-sentence report, and this is a report compiled by a social worker, and you can get a correctional supervision report before the sentence is passed to also support your request if maybe you are considering that the accused should be given a sentence in line with a correctional supervision. So the pre-sentence report would be compiled by social workers from social development, and the correctional services has social workers who are called correctional supervision officers. And when you get this report for the correctional supervision, you are either looking at maybe the accused serving a sentence that is for imprisonment, but would be including correctional supervision. And under that correctional supervision, they would maybe at a specified time, they will not have to complete the entire sentence in custody. They would be eligible to early release, provided they are going to be undergoing correctional supervision while outside. And the officers from correctional services will identify a place or the activity that the accused would would do under correctional supervision, and they will be able to check on them to see whether they are complying with the correctional release supervision. So that can be where also you are looking for the accused to serve a community service. If you want a community service, then they will identify a place, whether it's a school, whether it's a community center, and they will decide on the activities that they will be doing at that particular place to serve the community. And they will say how long and how often they need to go to the place and do those activities. That is coupled with their sentence. And if they are doing well in it, then there would be nothing further to that. Once the period that is determined for them to undergo the correctional supervision is completed, that is the end of the matter. So those are good if you are seeking maybe to avoid direct imprisonment and you want the court to take a closer look at the personal circumstances of the accused. Say, for example, you have an accused who is also a caregiver of minor children. So, yes, they've committed a crime. Yes, they need to be sentenced and punished for what they have done. But when the court, it needs to also look into the impact that sentence, if it is a custodial sentence, the impact of that kind of sentence on the minor children. And the only way to know whether these children will be left destitute or, then is to take a closer look who are close, maybe like family members, those who know the personal life of the accused, to give a clearer picture of the position that those minor children will be left in when this the primary caregiver is now sentenced to be in prison. So yeah, just please take note of that. There is also a situation whereby you can have a change of a guilty plea which was entered in court, and the court itself, after the plea is been entered, is not satisfied that that plea qualifies to be proper, and the elements maybe of that the alleged offense are not fully admitted, or where the court finds that this plea that is being made in court is actually having a defense that is being raised in the statement that is being made to make that guilty plea. The court will change that guilty plea. The same court will change that guilty plea to not guilty in terms of section 113 of the CPA. What is the effect of this now happening? This is someone who came before the court and said, I plead guilty. They gave a whole story of why they say they are pleading guilty. After they gave the story, the court says, no, I don't accept that you are, fully pleading to the charge and the concerns are this and that. What is the effect? Of course, this person now has to go through a trial. And now, if the accused initially pleaded not guilty, he is entitled also, please note, to, at any stage of the proceedings before the court gives judgment, to change the plea to guilty, okay? So where the accused has already entered a plea of not guilty, state witnesses have already testified, the trial is in the middle. Now this accused is having a change of heart, maybe after realizing that, no, this boat is fast sinking. There's no way I'm gonna survive this. And also maybe because of how you have tried without any, luck to challenge those, the evidence that is being presented, but you are not in any way able to crack the state case, and you go back to the accused and you ask them, what do you still want to do? And they may decide that, no, it's fine, let's not dwell any further on the issue. I decide to come clean and I want to plead guilty. So because the trial is already in the middle, you can't change the plea from not guilty to guilty, procedurally speaking. What you can do, you can make a statement in terms of section 220. And that's a very popular exam question as well. When you do this, you are going to make admissions in the statement, which are now going to show that, to the effect that you are admitting the allegations against the accused. So please note the difference between a section 112 guilty plea and a section 220 admission statement. They look alike, but the best way to tell them apart, this is what I say. With a section 112 guilty plea, which is on this slide, section 112 guilty plea, that statement cannot include anything that is denied by the accused. It admits everything, all the allegation, and the story even corroborates that of the allegations of it's in line with the state case on a 112. But with a section 220, the accused will admit that he went to the house, broke the door, entered without anybody allowing them to. Once in the house, went to the fridge because they were hungry, took food, eat. But the accused in the 220 admission statement, they can also include a denial. They can deny that while they were in that house, they never went into the bedroom and stole the Rolex watch that was in the cupboard or in the closet in the bedroom. So what does that mean now? Remember, this is still in a trial. If there's anything that which is denied in the section 220, okay, let's start with the situation where there is nothing denied in the section 220. If everything is admitted in the section 220 admission statement, then the accused confirmed it, and the court will then accept that 220 statement as admissions, and it will be evidence that is sufficient for a court to can now pass a conviction on the accused. Okay, but if there's admissions, and then somewhere in that section 220, there's denials. I deny I didn't take the Rolex. I only eat in that house. I didn't take something there. Now, that statement will still be read into the court record. The accused will be asked to confirm the contents of that admission statement. And after they have confirmed it, the court will accept it as an exhibit, and the admissions will be now considered as evidence against the accused. The parts that are denied will call for the state to now produce evidence to deal with those aspects that are denied. So the state will call a witness who's coming to testify about the parts that are denied. So when the witness gets there, they will be told, accused has already admitted, but they are now denying that they also took a Rolex watch in the bedroom. Now the witness will testify to say, yes, indeed, but they also did take the Rolex watch. So after they say that, it means the defense must cross-examine that witness to deal with that part that is being denied by the accused. And after all the evidence is presented by the state, then you will go into arguments where the state will argue that the court should find the accused guilty, and the defense will argue for not guilty based on the aspects that were denied. You understand? And the court will have to pass judgment. It's like a normal trial. And the accused can also testify after the state case is closed to cover the admissions and the denials, and then arguments, and then judgment to say guilty or not guilty. So the such admissions which are made in terms of section 220, if there's no denials, it's conclusive proof of the facts contained in that statement, and the accused will be found guilty and convicted on the basis of that statement. And where the state after this and where in the state has led evidence, closed its case, if the evidence presented against the accused was overwhelming, the defense was unable to discredit it, that's when the client would be advised to consider changing the plea or entering into those section 220 admissions. Okay, so this can be, for example, where the trial of a rape started, which happens a lot. The trial of a rape started with the DNA results not available. And the state case runs, and just before the state case is closed, the state stands up after their last witness and say, boom, the results are now, they've just become available. And honestly, they've just become available. They are shared with the defense. And guess what? Because you went through a trial, it was a denial, a bare denial of any, sexual conduct having taken place, sexual intercourse taking place between the accused and the complainant. But now the DNA results come back positive. So what would you do there? You will confront the accused with the DNA results, and if really they don't have anything that they can say to dispute the contents of the DNA results, then you would advise the client that then consider changing your plea and make some admissions before you have to wait for the hammer to fall from the bench. You understand? So at least it shows that there is some level of, humanity that is still left in you, though the court will still see it as the accused, when the state argue, they will say the accused only changed because now he was caught, with his pants down and depressed against the wall. It's not like they volunteered from the outset to plead guilty. They only did so only because of the evidence that they couldn't challenge anymore. Wara, 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 wara. But yeah, everybody will say their say. And at the end of the day, you would advise, and that's a scenario where you can consider a section 220 admission. Next topic is criminal capacity. And the relevant sections that we are just generally dealing with. It's Section 77, Section 78, and Section 79, interlocutory procedures. Sorry, that's a new topic, yeah. So Section 77, 78, 79 of the criminal procedure, we are talking about the the capacity of the accused, and we deal with it in this fashion, that at any stage when you are in the middle of the proceedings, at any stage of the proceedings, earliest available in the middle of the trial, just as the court is about to, pass sentence, the conviction has been given, at any stage, as long as the matter is still before that court, it transpires that the accused is unable to follow the proceedings, and there is a question surrounding their mental fitness to stand trial. The court must hold an inquiry to determine whether this accused is fit to stand trial. And when the court does this, it will do so based on the information that is presented before it. And the court will, in this inquiry, then after hearing evidence, if it is found that there is something lacking in terms of the mental fitness of the accused to stand trial, the court will order that the accused be sent to a mental institution for mental observation. During the inquiry, you can call witnesses to testify about the history of the accused. You can use medical proof if you have medical records from any health clinic or hospital to show or suggest that there's allegations of mental unfitness on the part of the accused. But if you don't have medical records, there could be a family member who knows the accused from when they were young, and what they will come and say in court is to the effect that, yes, this accused, grown up as they are before this court, is someone that we, even in the family, we know that they are not mentally okay. You hear the words that I'm saying, mentally okay, like something is wrong with the accused mentally. So because we are dealing with lay people, we don't have to be technical and give the medical, diagnosis of the actual sickness that the accused has, but we will just have to suggest that it relates to their mental fitness and something not being okay with them mentally. Sometimes you may not have anyone that can testify to that effect, but when you consult with the accused, you pick it up yourself that, is this person okay? You are questioning the mental stability of the accused based on maybe their conduct or maybe how they reason with you. Then you can bring it up to the court and say, I'm having trouble even to get proper instructions from the accused, and I'm suspecting. You are not a medical expert, so you speak based on what you observe. I'm suspecting there could be something wrong mentally with the accused. And for that reason, I'm asking the court to hold an inquiry in order for this court to possibly order that they go for mental observation. So this is not a strict thing, and it's not a difficult thing to do. But it is very important that at the earliest available opportunity, when you pick it up, when anyone comes and suggests it to you, even if maybe you might have missed it or you were seeing it, but you were maybe thinking, it's probably the stress of being in jail, because jail is not a nice place. But if anybody can come to you and say, this person is not all right, you cannot ignore that information. You must place it on the record that there's this information suggesting that there's something wrong with the accused mentally. Leave your biases aside, whether people are trying to escape prosecution, hiding behind these sections, and that's not your job. You are there to bring this to the attention of the court. That is the job that you have. And you are not an expert to say whether they are lying or not, whether they're trying to. Remember, when they go for mental observation, the reports will come back from the experts who have done proper checks and observed and tested on this person to determine whether they are mentally fit or not. So you just pick what you have in before you and make sure it's on the record. Yes, Richard.
I just want to say, Elsie, you share sentiments, and I know I'm keeping up. I see you still got 9 of 27 slides left. And maybe I should, I see Janus already Googled me or whatever. But what I want to say is, maybe I should just say it as it is. I was involved with the case in the Western Cape when I was still in the police, the Station Strangler case. Norman Afzal, we arrested and everything. And what the attorney or the William Booth brought that time to the court was, and he was arrested, he appeared in Kleinvlei Court and then transferred to Mitchellsplein Court and then to the High Court. His defense raised mental illness.
Okay.
And he was sent to Falkenberg at the time. And it's very important for defense attorneys to raise that mental illness, because the state will then appoint the professor that was at Falkenberg that time, assessed him. And it's very, very important, and it links in. Is your client, does he have the capacity to stand trial? And that's importance of, when you're a defense attorney, is to say, refer your client when it comes to mental illness. So yeah, and yeah, he's been released on parole last week. I just want to, it's very important to do that.
Yeah. And then what happens, Richard? I'm not really asking you to answer. I'm just continuing my talk. What happens when you make this suggestion to the court that there could possibly be something wrong mentally with the accused, which affects their mental fitness to stand trial?
Yeah. And we were worried there that he might be declared as a state president patient.
Yeah. So, look, hopefully when you make the request, the court will go along with you. They will be sent for observation. The report will come back from the doctors to say fit or not fit. Well, this is the position. If the report said unfit to stand trial, then the consequence is that the state would have to ask that the accused be considered as a state patient and then referred back into the mental institution to receive treatment. But please note, yeah, no, that's the thing I want to say. It's not always for life, because I've come across cases where they were referred as state patients, and at some point, I don't know, is it because of there's a problem with these mental institutions of space. So they do their own assessment of the patients, and at a stage where they feel that this person can be released as an outpatient, still continue receiving treatment, but as an outpatient, they identify them and they still receive treatment from outside. They only come and take treatment, yeah, when scheduled to do so. So please, it's supposed when they leave court, we all think it's for life. They are never going to see the outside world. It's like a lifetime imprisonment, but no, not all the time.
And sorry, Ma'am Elsa, now I'm taking up time, and even if we look at the latest case, the burning of the parliament with State versus Murphy.
Yes.
Yeah, being referred in and out into, but yeah, that's Darlene Pofu's issue.
Yeah. Yes. So, okay, now we know, we all assume that if it's a state witness, I mean, state patient, then they would be there forever. But we know that at times they say if their condition has improved so much that they do not pose a danger to the public and obviously to themselves, they are now going to release them to receive treatment as an outpatient. Now, what happens if the report comes back and says fit to stand trial, but you still are battling with that issue of fitness? You're still not convinced or not able to get proper instructions. Then what do we do? I'm hoping, is it Makasane, hopefully just closing that topic for us. Yes, Makasane?
Yes, ma'am. Can you hear me, ma'am?
Loud and clear.
Yes, Richard just brought some memories back when I was a police officer too. I was part of the task team that investigated Moses Sitole, the notorious Gauteng serial killer. During the trial, his lawyer actually indicated that he seemed not to be mentally okay, and the magistrate then, before it was transferred to the High Court, requested that he be transferred or taken into Krugersdorp Mental Hospital. That was done for observation. Sorry? Yes, yes, ma'am. And the reports came back and negative to say this guy is fine. There is no indication or any way that he is mentally not okay. Yeah, just to support that statement as well.
So it happens a lot that they do go there, and I don't know, maybe because even in my own case, I've had a lot of reports that came from Sterkfontein. They said fit to stand trial. Very few that said unfit. So you can decide when you get a report that says fit to stand trial, but you still disagree with the doctors, and you will have to go through the report itself. Sometimes you may find that it's one doctor who did the assessment, the mental assessment, and maybe you can call that doctor to come and testify and address your concerns based on the observations that you are making as a lawyer, lay person in medicine, but still of the view that maybe this one doctor missed something, and you can request that this doctor in court to speed up the readmission, that they agree to have this accused back for mental assessment, and this time around they do this as a panel, maybe of at least maybe 3 doctors, which would be a psychologist, this the head doctors, psychologist, normal medical
psychiatrist, ma'am.
Hmm?
Psychiatrist as well.
The psychiatrist, yes. So the head doctors. So at least if it's a panel compared to just one doctor who are looking into this patient, then at least if all of them, they still come back and say fit, then it becomes more difficult. I know of situations where people also get involved when there's funds, and also run their own independent assessment, mental assessment of the accused, and also present their own reports to counter those of the state doctors. So remember, with evidence of this nature, the only way really to particularly challenge those doctors is with another a doctor, because yeah, that's the only way, because their evidence is of an expert. So you can't just come with your legal knowledge. You have to present evidence also of your own medical records as well, compiled by medical experts on behalf of the defense. Then the court will be sitting with the two reports from these doctors, and it will have to weigh up and decide whether what it will do. But what I can say, when there's too much noise really and fights to that extent happening about the mental ability of the accused to stand trial, and it happens that at the end the court, proceeds with the trial, that accused is found guilty. When you appeal that sentence, this factor of mental fitness will be a very strong ground for appeal, factors that would be present in that case, because the judges, they don't like to take chances with suggestions that people were being said to be medically unfit, and there were reports of doctors who were disagreeing on the factor of whether this person was fit or not fit, and the court decides to go on and convict. That kind of a case, it's likely to succeed on appeal. So yeah, just note that as well. So I've said it, when they've gone for observation, they are admitted, the report will come back, a medical doctor, a psychiatrist compiles the report. Report says the accused is mentally fit, but defense wishes to challenge it, call the doctor, testimony in court, get independent report, counter that of that doctor's, your own clients, with, of course, your own at the client's expense, because that one where the client is sent, it's the state doctors who do that. So please take note of the difference between mental illness and mental retardation, because many of these reports will come back saying that the accused is fit to stand trial because they are not mentally ill. They actually have been found to have mental retardation. Mental retardation ordinarily does not, in terms of the reports, the doctors will come and say they don't have, they're not mentally unable to follow the trial. But with mental retardation, please take note of severe cases of mental retardation, which can lead to mental illness. So please note the effects of the extended use of things like drugs, which can actually be making a person to end up with mental illness, or your severe cases of depression, So please take note of those cases and determine, even if the condition would ordinarily be mental retardation, But how severe is it? Okay. Moleboge.
Ma'am, evening.
Evening.
This actually raised a question I have. I'm sorry to disturb the class.
No, you're not. You have to ask.
In a case where someone was held in custody, ne? Because of mental illness, and then I think the police were the ones saying that they are still looking for an institution for the place, but they held him in cells, ne? They held him in prison. What happens when they don't find an institution? Because with some areas there's no support of institutions for mentally ill people. What should happen to that person? Should they release the person back to his home because they cannot find an institution that can help him? Or is it okay that they can still hold him in prison because of the danger he poses to himself and the community?
Sorry, I'm back, Molebogeng. I'm asking you, if it was your client, what would you do?
It was not my client. I actually got this
I'm
question.
asking if it was.
Oh, if it was my client. I'm actually confused, ma'am, because this person having done some certain things in the community, his life was in danger. So the police took him after the community had called the police. The police took him, but then indicated that there's no place they can place him because of his mental situation. So I'm confused as to whether I'd prefer for him to be released because he's a danger to himself and the community, but at the same time there's no institution around that area, unless maybe he should be maybe moved to a different province or different area. I'm not sure. I never really followed much because I think the family was waiting for the police to maybe find something for him, because even the family did not want to take him in. Well, he's actually left with his siblings.
Yeah, with that kind of a danger, that's why I said before they are released from the mental institution, for those who do get released, they would say, they are comfortable that the accused is not a danger to themselves and to the public. So you are saying this person is a danger to themselves and to the public. So I wouldn't ask that they be released, because now you say also further the community is also looking for his head. Then maybe then you would rather try for the state to consider checking in other provinces. Obviously, this is not a prison is not a mental institution, and if there is really something wrong mentally with that person, this matter cannot stay on the roll because they will not be able to stand trial. So the state will be then rather be encouraged to check with other provinces where this person can be booked into institutions, mental institutions, because they are there. Unfortunately, the mental institutions, most of them have long waiting lists. So people do tend to sit in custody, especially the dangerous ones that you can't even fight for them to be released in the care of the family, So for those ones, then you are left with no option. They will have to stay in custody, but you have to push that the state seek other provinces to get themselves into a mental institution, because it's like a punishment. It's unfair that they just sit there, if they haven't been sentenced, because they need medical treatment. So yeah.
Also, sorry, it's Richard again. Yeah.
Thank you, ma'am.
If I can just maybe advise my learned colleague there is to approach the Department of Social Development. They do have facilities. Thanks.
All
Okay,
right.
thank you very much.
Thank you, Mlebogeng. So we've spoken about a trial within a trial, ladies and gentlemen. I've given you the different scenarios, and especially how Malitolel. Mr. Sambo.
Can you hear me?
I've opted to change my network. Let's hope we are safe, even if we have load shedding. Hopefully this one will do better.
All right.
Good evening, Mr. Sambo.
Good evening.
We can,
just on this note that you're in, I was privileged enough to follow the case. I don't know if anyone is familiar with it. The case that involved a gentleman who's a former member of SAPS, who went on to shoot his girlfriend in Tembisa Hospital. I think it happened last year or the year before. So I followed the case and the judgment, where the judge did sentence. He in his words, he just said that you are sentenced to life, because the gentleman is paralyzed now and is on wheelchair. And he mentioned in his words that there's no facility, correctional facility, that can be able to accommodate you. Therefore, you become a burden to yourself, and you are sentenced to life on your wheelchair. So I just wanted to find the rationale behind that, because there's people that are aware that there's certain judgments or the certain sentencing that could follow them. Therefore, they would do some grievous bodily harm to themselves just in order to escape the prison stay. What is our law with regards to that? If there's anyone that can maybe try and school us when it comes to that, because of it could be a trend that could be followed in South Africa, that people could just go and disturb their spinal cord area so that they don't get to suffer the wrath of law. So I just wanted an insight on that, because now he's not in any facility in South Africa. He's just sentenced at home.
Okay, briefly there, without wasting too much time on that matter. That man got himself paralyzed because he was trying to kill himself. That's why he's in a wheelchair. There's a condition, I don't know what is it? Yeah, there's a term. Maybe if someone knows the term, they can tell us the term. But he is rendered, like his organs, like he's basically a cabbage. Like he can't do anything for himself. He's just breathing. That's the only thing that's left with that guy. After he shot the woman, he shot himself because he was trying to kill himself. So when the judge said you are sentenced to your own wheelchair, it's because really it would be even useless to take him to any jail, because the needs that he has would not be catered for in a prison, because he's just somebody who's breathing air. He can't do anything. He's passing number one, number two on himself, like literally a vegetable. Yeah. So that's what the judge meant to say. There's not even a need to send them to jail. They will die sitting on that chair one day, basically.
So ma'am, just to add on that, wouldn't despite his physical inability to become a threat in the society, wouldn't we then say that because of when the incident, luckily I was in the area of Tembisa when the whole thing happened, and there was like a bunch of nurses that were there that there was the mob outside of the area of Tembisa Hospital that wanted to come for him. And in some of the utterance of his words was that, I'm a member of SAPS, I have friends and stuff like that. Should you want to come for me and stuff like that, I am after your heads. So wouldn't he influence then, because he has the capacity to speak, he has the capacity to influence further criminal activities. It's just that he cannot, in his own body, actually go and do those things. Then what is the provision? Because he can still talk. So for me, it's like a mafia member who's just like in prison, but who can influence the outside world.
Sorry, I'm muted. I didn't see. Sorry. So that person, it's an own goal. Like that's like what I was saying, that I don't see, the court obviously was presented with enough evidence and all the concerns were addressed, and it was well suited for him to be sentenced in his own wheelchair. Let's not but yeah, you can read up on the medical state of that guy. Oh, somebody says C5 quadriplegic. Quadriplegic is very, very severe kind of disability, is disabled in every way, really. So that's why I said all he can do is just breathe. Yeah, and talk nonsense, basically.
No, thank you so much. Thank you so much.
Yeah, that guy is an own goal, my Mr. Sambo. Really, I wouldn't even fear. Even I'll slap that mouth that is busy talking nonsense. So, in fact, the guy is better off if he would have died, because really the life that's left for him is pain now and misery. He's in a worse off condition than, you understand, if he was, at least, because now he's just suffering, daily suffering. He's just, yeah. So yeah, spinal cord injury was just so bad. Paralysis, both upper body and lower body. Yeah, just. So that's why the judge said that. Okay, let me move my slide. Oh God, what did I do now? I think I'm getting tired. Okay.
Don't say you're getting old, eh?
No, I'm very young, spring chicken. And trial within a trial. We spoke about it, guys, and we said we are trying to settle disputes when there is an issue concerning the admissibility of that evidence. I've given you the example of, a state trying to introduce self-incriminating statements like a confession with Gumede. We spoke where there are inconsistencies with the state witness statement made to the police compared to the evidence they are giving in court. And we spoke at length with the arrest and the seizure of arrest, search and seizure, which is challenged in court in a trial within a trial. So another interlocutory procedure is a review. So the matter may be in the middle of a trial. Before it's concluded, issues can come up in terms of how the trial is being run, and if there's anyone who's challenging maybe the jurisdiction of that court, or that maybe the presiding officer has an interest in the cause, is likely to be biased or display malice or corruption on the part of the presiding officer, or that there's gross irregularity that is taking place in the proceedings, or that the court is admitting evidence which is actually inadmissible, or the court is rejecting evidence which is actually admissible. So you can follow the review process, and you have to now wait for the outcome of the review before you can continue with that trial. When the outcome is there, it will give direction whether the matter is to proceed as is, or then the whole trial will be directed that it was, run and incorrectly, and therefore the direction would be whether it starts de novo, whether the trial, should be sent to another court, to another presiding officer. So a clear direction will be given there. So even when you are dealing with a recusal of a presiding officer, where you are saying the presiding officer has an interest on the outcome of the matter, the person to be tried before them will likely suffer prejudice. Then you will apply for their recusal. There is situations where you can have a self-recusal of the presiding officer. We have seen that, I think it was Zuma's matter with the Honorable Judge in KZN, who then informed that he would not be able to deal with the former president's matter. So that's a clear example where a judge had recused themselves without even being urged to do so. But also where a presiding officer can say, I have previously convicted the accused, I know him, so obviously in my eyes is a convicted felon. I'm obviously going to be not be able to look at them, as the presumption of innocence requires that I look at every accused before this court as innocent until proven guilty. But if I have prior knowledge of the fact that they are convicted previously, then the court can excuse themselves from dealing with that matter. Or the accused, or rather the presiding officer, is said to be prejudiced when conducting the matter, has a motive in his host. The presiding officer is, or maybe the court has found the accused to have been a hostile witness in the past, maybe in another trial, where maybe there is a suggestion that there is a motive on the part of the presiding officer to rule in a particular manner, that they are influenced they're going to be said to be influenced to rule in a particular way. Where there's those kind of things, the court can recuse itself, because presiding officer should be unbiased and fair in their ruling. So when they refuse, because they refuse to recuse themselves from a case in which they ought to do so, that will be a good ground for taking that case on review. And you are going to allege that there is bias on the part of that presiding officer. Okay, so the last method to dispose, this is the last method to dispose of the case, is the trial. And I'll run with it, but I'm not going to go too deep on this one, ladies and gentlemen. Jackie, please mute yourself. Okay. So with a trial, I'm not going to be too deep with it, ladies and gentlemen, because I know for a fact that you are going to do litigation techniques. All the strategies and everything will be dealt with there in the trial. So, but I'll run through it in any event by simply saying a trial starts with a state case. And from the state case, it's the prosecutor who reads the appearances into the record, introducing the matter, and puts the charge to the accused. The accused is then asked if they understand the charge, and they will then be asked how they intend to plead to the charge, right? Now, if they say not guilty, this is a trial. Then the defense lawyer, who is yourself, you will confirm the plea of not guilty as it's in accordance with your instructions. Then the defense makes a statement in certain cases, or you can remain silent. So when you make a statement, that statement will have to be confirmed by the accused, because that statement can be considered as evidence already by the court. So when you know that, for instance, this is when you need to know when to make a statement or not to make a statement. When you know that your defense is that the accused was present at the scene, they are linked to the commission of the offense, and your defense is going to be self-defense, you must make a statement. I said must, because if you don't make a statement, you do now proceed with the trial, and later on, you bring it up that the accused is actually raising a defense that they were acting in self-defense. It's not obvious, but it may look like the accused was waiting to hear how the state witnesses were going to testify. And now that he hears that he's being linked to this offense, he's now adapting his story and coming up with a defense which was never there from the outset. So when you disclose from this statement at the initial trial, at the outset of the trial, it shows that this is clearly the position of the accused in terms of how he intends to defend himself, and it's not something that they are creating or building up or making it up as the case is going on. So it's very important that you must disclose that at this stage. And also, where the accused is raising a defense of an alibi, you must disclose that here before the state witnesses come to testify. Your opening statement will be, the accused pleads not guilty to the charges, and he's raising a defense of alibi. The alibi will be called is LC, who will come and tell the court that the incident or the allegations which are said to have happened to the accused being there, the accused was not there. As per the instructions of the accused is going to have the alibi come and confirm to this court that at the time, on the day of the incident, the accused was actually not even in the court's area of jurisdiction. He was actually in a foreign country with the alibi, who is coming to testify in court to that effect. Or he was in another province, or he was in another town with that alibi, who's coming to say they were with the accused at the time of the incident, meaning the accused was not at the scene of the crime. That is something that must be disclosed there. Now, if you've read the statements of the state witnesses and your instructions from the accused is that they were not there at all, and it doesn't look like the state really will be able to, though they will try, obviously, because there's witnesses pointing to the fact that the accused was involved in the offense. But your instructions from this accused is that they were not there, they know nothing, they didn't do anything. So there, you can just merely say accused plea is confirmed as per the instructions of not guilty, and the accused will elect to remain silent, or you can say the accused will just make a statement to the effect that all the allegations made against him or her will be denied. Then you sit down. State calls first state witness to testify. Evidence in chief of this witness. Evidence in chief of this witness is led by the prosecutor. Prosecutor will ask no leading questions to that witness. You must look out. No leading questions. The prosecutor can ask, ma'am, how were you assaulted? Tell the court where you were when the incident happened. What were you doing? Who was with you? So all those kind of questions, eliciting information to come from the mouth of the witness. Allow the witness to tell the story in their own words. Prosecutor must not put words in the mouth of the witness. For instance, the one leading evidence in chief cannot say, ma'am, you were assaulted by the accused on the 16th of June, 2023 at Pretoria. No, you have to object to that. Ma'am, tell the court what led you to come to court to be a complainant in this matter. That's fine. So the witness will now, in their own words, tell the story. That's a rule with evidence in chief. Cross-examination, now after the state has done their part, you jump up, you big shot lawyer, you now start asking leading questions. Now you may tell that witness a statement that they can react to. Preparation for this cross-examination is of utmost importance. No, I'm not taking your question. The better you know your case, your defense that you are raising, the scene of the crime, the better the questions that you can ask in cross-examination. You ask questions that you anticipate the answer to. You should know what answer you are expecting to get. And the best way to do that is to ask short and direct questions that will channel this witness to answer yes or no. Ma'am, you are the complainant in this matter. What answer are you going to get there? Yes. So like, I guess you understand, but it happens at times that when you are asking these questions, you should avoid open-ended questions which elicit an explanation from the witness. Do not ask a question that is going to start with, why did you come to this court, ma'am, to say that the accused is the one who attacked you? You are going to get 1,000 answers to say why they say the accused is the one. That is a bomb. Make a statement to the client which calls for a response without abusing this. I put it to you. I see in this Senzo Meyiwa trial, those lawyers seem to be doing fairly well. I guess I haven't really seen a clip that's showing them saying, I put it to you. Hey, I put it to you. Stay away, guys. Please stay away from that thing. We must run away. Run with two legs. Run fast. Don't say that thing, please. It's irritating. Make a statement.
Elsie,
no.
Sorry, quick. Elsie, do you know why? Darling Pofu's not there.
Richard. Richard.
I would draw. I would draw.
Better.
I would draw. I would draw.
Better. So where the witness answers with an explanation, because you are trying to put a statement that is eliciting a confirmation of yes or no, or they agree or they don't agree, right? But you will see that at times these witnesses, they are answering with an explanation that you didn't ask for. Call them out and say, ma'am, please answer my question. I'm not asking for an explanation. Do you confirm that this is what happened, or you don't? Do you agree or you don't? You understand? So you have to control the witness in that way. You determine also which style to use on a witness during your consultation stage, because the facts will tell you whether you are going to be going the soft approach or the hard approach. And by this, I mean, there are those sensitive cases that call for there's the most sensitivity when you are dealing with those witnesses. This doesn't stop you from cross-examining, because when you show the human element to those, traumatized witnesses, right? We don't deny that they underwent a very traumatic event, but we are just saying the accused is not the one who did that, right? But it doesn't mean you have to be inhumane and inconsiderate of their, ordeal. So you can say to that witness, ma'am, the incident you went through is very traumatic, and I really fully sympathize with you for the ordeal that you went through. You see, you are just expressing your empathy to the witness, and you can even twist it and say, ma'am, you went through a terrible ordeal on this particular day when you were attacked. And what answer will you get? Yes. And ma'am, it was the most traumatic event, I guess, to date, as you have testified before this court. Oh, yes. Oh, ma'am, may I even take an opportunity at this time to express my sincere, apologies to you for this event that happened to you. It's really bad what you went through. Thank you. Okay, why do I say this? Soft, hard approach. Remember, this witness has been prepared that when you come to court, there is this lawyer who's coming to defend the person who attacked you. They want to get that person out, you see, and prove to the court that that person is innocent. Preconceived formulations in their mind that all you are there to do, they know you are just coming to try and show that the accused didn't do it. So when you come with that kind of different approach in that way, it disconnects them from their, whatever thinking that they came there with, where they were just going to be resisting and denying everything that you were saying. So when I say a soft and hard approach, it also unsettles the witness if they came there with an attitude that is meant to be hostile or negative towards you. It makes them feel at ease. And, when you see that the witness is maybe crying or whatever, you don't have to keep hammering. You can, of course, be considerate and say, look, I see, ma'am, you are crying. Maybe, Your Worship, we can give the witness some water, maybe we can, maybe you give the witness some few minutes to compose themselves, you know, so kind of things like that. So that's the soft and the hard approach. You will work it out, you will decide. I don't know a school of thought that says you have to be in a particular way, but you will work it out. Surprise witness is a witness that sometimes you may find the prosecutor trying to introduce a witness who did not make a statement, and they will tell you they just found out, or that witness was mentioned somewhere, so they want to call that witness to testify. Please be on guard. You should object to the calling of that witness. You can even obviously see it as ambush because you have no idea what that witness is coming to say. You had no opportunity to prepare yourself and prepare the accused on how they would respond to that witness statements once they are testifying in court. So that witness can actually be coming with a bomb to just finish off, you know, the accused, and to make a comeback, if allowed to testify, it will be very difficult to erase their words from the mind of the court. So please note that there are some presiding officers that will order the prosecutor that, okay, I hear you, defense. Yes, you didn't know. Yes, yes. But please, maybe you and prosecutor can sit with that witness and you, prosecutor, consult with that witness in the presence of the defense, and, you know, in order for them to be able to, can be able to come and testify. Still, challenge it, don't allow it. It's wrong, it shouldn't be allowed. Re-examination is after cross-examination. So with re-examination, you are going to ask questions to do damage control. The questions you are asking here should have come out of that cross-examination. So here, new evidence is not okay, like you're not going to have new evidence being introduced as the prosecutor or you as the defense when you are re-examining your witness. Whatever you are dealing with in the re-examination should have been out of what came out during the cross-examination. So when new evidence is introduced, you have to inform the court that if this is allowed, you will have now to cross-examine on that new evidence that the court is allowing. Please note that. Recalling of witnesses, it happens that a court can allow a witness who already testified to come back after they were excused. They left the court. They have to come back and testify further. You can make that request. The state can make that request, but often you as the defense, you would request if maybe you didn't deal with the case itself initially and you just came on board and maybe you feel that there's very important information that was supposed to be put to that witness, and then you will make that application. So when you as the defense, maybe the state is asking for that, you should know when to raise a valid objection to that witness being recalled. So the court, in allowing that witness to testify, they will have to find that it is in the interest of justice to allow the testimony of that witness, and also check whether there will be any prejudice suffered by the accused which may render the trial unfair. So the court can also call for further evidence of a court witness. This is a witness who wasn't called by either the state or the defense. If maybe when the testimonies are going on in court, there's a name that keeps popping up, and no one has called that witness. that's when you are most likely to have the court calling that witness as a court witness. Please note, when the court makes a request for this witness to be called, that witness comes before the court. And I've seen at times that when they arrive at court, they will be interviewed by the prosecutor. That is not a state witness. It's a court witness. The only thing the state has to do is to get that witness at court. And when they're at court, they can just tell the witness that the court has called you here. They don't have to discuss the case with that witness. If you are of the view that the witness has been influenced in any way by the state, you can even object to that witness testifying. So be careful that this should not be an opportunity also to close gaps that the state had left open, because that happens when there's an incompetence maybe on the part of the prosecutor. You know, some members of the bench, the presiding officers also are former prosecutors. So when they see that there's a huge gap there, sometimes they try to close the gap, but that's not their job, because theirs is to seek clarity and deal with the evidence as it's presented before them. And in their clarity seeking also, be very careful. Ne? So, yeah. Okay, we spoke also, I think, on the discharge in terms of section 174. The test is whether the state has failed to make a prima facie case against the accused. You deal with material contradictions, improbabilities in the evidence presented by the state to show that the evidence was of such poor quality that there is no reasonable court that can convict based on that evidence. So please note that there are some courts that will not grant the discharge where there is more than one accused involved, for the fear that if one is accused, one accused is released with the discharge of 174. During the defense case, that one who's left may likely come and blame everything on the one who's been released, and nothing else can be done about that because that one has been found not guilty and discharged. So they do tend to, when there's more than one accused, they will refuse the 174 and expect you to call both of them to testify. Now you will decide, are you going to call both of them? Or if you find the evidence is really non-existent, then you advise, I'm not going to call you. There's nothing they can do. Defense case runs in the same fashion that we lead evidence with the state case. Evidence in chief, cross-exam, and. Please, here I just say, please note the ethics that they should be observed, not to put the version in the mouth of the client. Because lawyers are very creative people. We understand you are very talented, you know, and sometimes you may overshare with your clients. But remember, yours is to take instructions, and if there's a need, you can advise, but do not give versions to the accused, because when they are in hot water under cross-examination from those very good prosecutors and they are now questioned, they do actually say, in fact, my lawyer is the one who told me I must say this. So please don't be that guy who's playing Mr. Smart Pants, or is it Smarty Pants? Yes, please keep your very smart brains with versions to yourself, please. I've seen so many people who will say, but you know what, if only the client can say it in this way, you could get, you know, no. Please don't do that. Do not influence any witness as to how they should testify. You can merely just advise and you move on. Cautionary rules, you see my slides are moving on because I've dealt with all this. I'm just making sure that I didn't miss anything. Sandile, I'll take your question, please. We are out of time, but I'm just trying to make sure I don't miss anything. Cautionary rules are there. We spoke about them as rules of practice. They are not created by any legislation. applicable in cases dealing with evidence of children, single witness testimony, complainants in sexual offenses, like in Jub's case, and accomplice. The aim is to avoid wrong convictions. That's why caution is applied on those kind of the testimony of those kind of witnesses. So you will notice that there's different attitudes that the courts have when they deal with the evidence of this specific type of witnesses. Because I think you can make out that generally they are considered to be vulnerable. Children are vulnerable, you see. Therefore, it is important that when we have those kind of witnesses, it's important to have corroboration of evidence to their testimony. E.g., cases of identity, it's not enough for the witness to give an honest identity and honest testimony. The court should take note of human fallibility with regard to observation, because people do make mistakes. Children imagine things and they are susceptible to suggestion. Therefore, they are easily influenced. So please note the challenges also raised by technology when dealing with evidence of photographs and videos. Photoshop is so, I don't even know, I don't have the words with, Photoshop, it's something else. And I think the authenticity of such evidence should always be proven before that kind of evidence is accepted. I think a nice example there for you is the current case of those, I don't know, they are bodyguards or what, those security of the minister or premier, I don't know. But I saw
Blue
that.
lights.
Yeah, the blue lights, bodyguards, security cluster, special security for the minister. They are challenging the authenticity of that video that the whole, I think, South Africa, most of it, we have seen it, because it seems like we don't know who took that video. So when you introduce evidence of a photograph or a video, you need to come and prove who took that photograph, which device did they use, and the device itself will have to be shown in court to say this is the original device that took before it was shared all over social media. And remember, there's memory in the device. It will show the time and the date of that incident. So expert witnesses, I've said it also, that not everyone is qualified to be an expert based on their educational background only. When you hear that the state is introducing evidence of an expert, you have to check also their experience in the area of their specialty, and you go deep. If they say this is an expert on ballistics, then you have to check, be thorough, thorough, ladies and gentlemen. I'm not gonna be too go deep. When I say go deep, I can go deep and we sleep here. Sentence, I've just highlighted a few factors that the court should take into consideration when it is considering a sentence. Please, this list is not exhaustive. It means it's not all the factors, but it will help you to be able to know the things that are generally obviously supposed to be before the court. When minimum sentences are applicable, we've spoken about the implications that they need to be fully explained to the accused, and you need to show those substantive and compelling reasons. Please note, if you have a case that involves consumption of alcohol, you see sometimes lawyers trying to raise drunkenness as a factor that influenced the behavior of the accused. Beware that where accused has consumed alcohol in order to gather the guts to commit a crime, that is a criminal offense. So intoxication is not a defense. It can actually be an aggravating factor if you try to use it, to rely on it. So be very careful. Before passing sentence, the court obviously balances interest of society, nature and seriousness of the offense, and the accused personal circumstances. That's like a song, but yes, that is how it must be applied. Nothing must be overemphasized or undermined. Okay. Appeal is this is our last slide actually. Section 309, you can lodge an appeal where you are when you are in disagreement with the ruling of the court based on the conviction or on the sentence. You can file or lodge your appeal within 14 days after the matter has been finalized, or you can elect, if you're not challenging, say you're not challenging the conviction, you can only appeal the sentence alone if you feel that it was too harsh. You limit it to the contents of the record in an appeal. This means you're not able to introduce new evidence, and you are limited to your grounds of appeal. So all your arguments, make them out clearly on the papers, and the appeal will be decided there. It can be argued, but you are limited to your grounds. So you can't go out of your stated grounds for appeal. Reviews, I've talked about it also. Just lastly to say that if you are against the procedure that was followed, there were things going wrong there. I've said inadmissible evidence accepted or including inadmissible evidence. There's a need for this presiding officer to recuse themselves when they are maybe interfering with you when you are trying to cross-examine. They are curtailing your cross-examination, and they are just being seemingly unfair the way they are running the whole entire case. Then you make your affidavits based on your grounds of review. You send it, and you'll get your outcome. Please also just check in your manuals. There's different types of reviews. You have the normal ones, the automatic reviews, which are normally where the accused were legally unrepresented. Special reviews, and please just know the different types there. So that's just by the way. Ladies and gentlemen, yay! Okay, so we are way beyond our time. I don't think really I left out anything. Millicent, don't you want to go home and sleep now?
Elsie,
do you have any questions,
Elsie,
Millicent?
I'm gonna ask everybody to put their mics on.
No,
and say,
wait, Richard,
well done, Elsie.
Okay, thank you.
We go 1, 2, 3.
We are going to sing Elsie the anthem. Let's sing Elsie the anthem. Somebody sing the anthem. Come, the anthem. Because easy Come on, guys.
Richard is drunk.
Elsie for president.
Richard, class, man.
Guys, the class is finished. Thank you very much. I've said all my lovely words in the beginning. Yeah, I send you all the love and the hugs and the everything of the best. Thank you so much.
Elsie, may I do this for you for the last time?
Thank you.
Yes, Elsie.
Another song, Richard. No.
Okay, wait.
No,
I'm going to do this to
no,
you.
not Richard singing. No,
I would like to thank
no,
Alshed
thank you, no.
for doing a very, very
Okay.
good job
Bye.
for the
I'm
law
stopping
school
there.
of South Africa.
Bye.
Bye.
Bye, guys.
Cheers,
All right,
everyone.
there you
Enjoy
have
the
it, guys.
weekend.
Thank you to us here in the studio. I'd like to say thank you to my colleagues Giannis and, of course, Richie and the gang, our producers. Wishing you guys a lovely, lovely weekend. We are about to wrap it up. Everybody